This is a lecture for my professional responsibility class, and we're going to be talking about Model Rule 6.2. If you are watching this for my class, you should watch this in conjunction with Rule 1.16 or Rule 1.16 because it actually uses the same standard. And what we're talking about here is judges sometimes will call lawyers in the area to represent pro se litigants or unpopular parties in their courtroom, and it could be that there's a prisoner appeals. Prisoner appeals are about a quarter of the federal docket, and a lot of them are indigent and can't afford a lawyer, and there's not enough lawyers for them. So occasionally, if somebody has a valid appeal or complaint or lawsuit against the prison or a prison guard, a judge may call a local lawyer and ask them to take the case. It's very common. You could also have someone who, immigrants or other people that maybe sometimes a legal aid clinic or a law school clinic would represent, but if there's not one in your town or city, a judge may call local counsel and say, look, there's somebody here who needs a lawyer. And of course, indigent criminal defense, but usually lawyers have volunteered to be called for that. And now, this is all about accepting appointments when the judge calls you and asks you to do this. And before we get to the rule, I do want to say, I'm going to spoil the end for you. They could be asking you to do it for free, but they can't make you do a case without compensation. On the other hand, the compensation doesn't have to be your normal billable hour rate. There's likely to be some sort of statutory set amounts that they normally pay indigent defense counsel and so forth, which means that for a lot of lawyers, it's a discount case. When you take these, and a lot of lawyers don't like to do them, to be honest, and that's why we have this rule. Here's our rule, and it's only one. The rule is only one slide. A lawyer shall not seek to avoid appointment by a tribunal to represent a person except for good cause. Stop right there. That means A, B, and C are types of good cause. But if a judge calls you and says, I want you to take a case, or the judge's clerk says the judge would like you to take a case for somebody who doesn't have a lawyer, there's a presumed obligation for you to take one for the team, for the legal community, and to do it. And if you're going to turn it down, you have to have good cause. And saying, I don't feel like it, or I've already done a couple of these this year, or something like that, doesn't count as good cause. Or I hate inmates, or whatever it is, that's not going to be good cause. So what counts as good cause? A, if representing the client is likely to result in a violation of the rules of professional conduct or other law. And so let's say you have an actual conflict of interest in the case, and you can tell the judge, I can't do it because I have a conflict. B, representing the client is likely to result in an unreasonable financial burden on the lawyer. Or C, the client or the cause is so repugnant to the lawyer as to be likely to impair the client-lawyer relationship or the lawyer's ability to represent the client. And I want to talk about each of these. The comments have sort of very wordy explanations of these, but I want to just explain it to you. So I already talked about A, which is something like you would be that you have a conflict of interest. It could also be something like you just lost your law license or got your license suspended. That's good cause, right? Your Honor, I'm actually not allowed to do any cases right now. I just lost my law license. There's a number of things like that that simply would disqualify you from the case. Another type of conflict of interest might be that you worked on the case that at an earlier stage on the other side, something like that. The unreasonable financial burden, we don't mean just that it's a setback or a bit of a sacrifice or something. We mean something like that this case, you can tell right away, is going to be all-consuming, and you will have to give up representing your other clients for the foreseeable future in order to undertake the representation. And this can happen, right? You can have a judge who has someone that they want to represent. I've also seen this sometimes with the windup of corporations that are declaring bankruptcy or something like that, where this is huge fiasco, and the judge will ask a lawyer to handle it. And if this is going to be so involved that it's not just going to be one extra case that you don't make as much on, but it means you're going to lose all your other business for a while, then that would be an unreasonable financial burden. It could also be that there's going to be a lot of out-of-pocket expenses or travel or something like that that you're not sure the court's going to reimburse, and you really can't afford it right now. C, though, is where it's so repugnant to the lawyer as to likely impair the client-lawyer relationship. And this, when you read the comments, they're basically talking about a material limitation under 1.7, Model Rule 1.7. So what are we talking about? This is someone who committed a crime against someone, and you yourself were a victim of that very type of crime, and you still suffer from PTSD from it. That would be an example. It could be that you have a personal history, right? That you actually knew this person growing up, and they hurt you, right? Growing up, and maybe that's not related to the case, but you have a personal history and grudge against this person, and those types of things. And it could also be the cause, right? You've devoted your life to pro-life causes, and you're asked to represent an abortion doctor who is being charged with crimes, which has happened, because there's occasionally there's a doctor who's not following health and safety standards and so forth, or is committing tax fraud, or doing something like that, practicing without a medical license, and or that you're an advocate for abortion rights and you're being asked to defend somebody who's an activist on the other side. So it could be something that's for you is very personal. Now, I'm going to skip over some of the comments. Comment 1 is basically saying every lawyer, as part of our profession, has some obligations to give back to the community and to do some pro bono cases and or represent unpopular defendants and things like that. Comment 2 gives an example of the repugnancy standard that we saw under C that can count as good cause. And again, they're talking about you have a personal history. This is something where this is someone who has done something that it's very personal for you. There's a special reason that you are disqualified from this. And then again, the unreasonable financial sacrifice could qualify. Comment 3 merely mentions that when you take a judicial appointment, it is still a client. Now, if the client refuses your representation, then there is no attorney-client relationship. But if the court just because you have a case you didn't ask for and you didn't want, and you're doing it because the judge kind of said to do it, you still have a duty of confidentiality and loyalty and all of the other duties that you have to a normal client. It's not like a lower standard of ethics because you're doing a case that normally you wouldn't have wanted to do. Now, but I want to focus on this, and this will be one of our last points in this little lecture. The most common excuse that lawyers raise to try to get out of taking an appointment from a judge, an appointed case, is that they don't know what they're doing and don't practice that area of law. So you have lots of lawyers who are just real estate lawyers or transactional lawyers, and a lot of these cases are prison inmate cases, or criminal defendants or things like that. And the person says, I've never done a criminal case, and so I'm not the one to do it. So this is the most common area where people try to get out of cases, and judges don't like it. And the standard, I can tell you we have decisions on this, court decisions and ethics opinions from the states, is that the mere fact that you haven't done a criminal case and you haven't thought about criminal law since law school does not count as good cause, because the idea is any lawyer could teach themselves to do a rudimentary criminal case and could ask for help and things like that. And so not a high profile or maybe a death penalty case or something, high stakes, but some of the routine matters that judges ask lawyers to cover you really could figure out if you, and if someone were coming to you and offering to pay you a lot to do it, you would. And so the judges don't like this, and they may actually ask you to come in and have a hearing where you make a showing of incompetence. Imagine you as a lawyer are going to have to go in and put on evidence of your own incompetence in order to get out of a case. You should have just taken the case. And the court may decide that you're capable of becoming competent, or may tell the lawyer to affiliate with other counsel. So even after you go in and try to pitch to the judge, like, I'm completely, look, Your Honor, I can't do anything except the most basic legal tasks. I'm not that bright, and I'm completely unable to learn how to do anything new. And the judge could say, oh, I think you could give it a good try, and still have you take the case. And I want you to understand under 6.2, you have an ethical obligation. You can't just say, no, I don't have to do it. It's a free country. This is part of sort of something you agree to by accepting a law license. Now, the flip side of that is there have been attempts of judges to make lawyers take pro bono cases without any compensation at all. And unsurprisingly, lawyers have challenged this as a taking of their time or their legal fees without compensation, and they usually win. A lot of courts have held that forcing lawyers to accept appointments without compensation constitutes an impermissible taking. So typically, the judges aren't going to be asking you to do it for free, but you will probably be asked to do it for whatever they normally pay indigent defense counsel, which could be less than you normally charge. And in that case, I think you're stuck. I think you're stuck. Now, can you get out of it for incompetence? Again, yes, if this is something that really does require a lot of expertise and it's going to be very complicated, and it would take you so long to get up to speed that it would be prejudicial to the client who needs representation, pitch it to the judge. But a lot of lawyers just use this as sort of a lame excuse because they don't want to be bothered. And that's the end of our little lecture about this.